I am TJ, joined by Diana. This is Bureau of Prisons Watchers for Sunday, June 7, 2026.
Welcome, everyone. We have a lot to get through today. Big policy news, a troubling medical report, and two Supreme Court decisions that every family needs to hear about.
We are going to start with what could be good news for a lot of families. A new Bureau of Prisons policy on home confinement.
This one is significant. Bureau of Prisons Director William K. Marshall III announced a new policy designed to expand access to home confinement.
The Bureau says the goal is to eliminate barriers to maximize the availability of home confinement for people who qualify for community release.
This applies to people who are eligible under the First Step Act and the Second Chance Act. Those are two federal laws that govern how and when someone can be released to home confinement or a halfway house.
So what does this mean in plain language? It means the Bureau of Prisons is supposed to be making it easier, not harder, to get to home confinement if you qualify.
And that matters because just last year, the Bureau of Prisons issued a policy that restricted halfway house placements and then reversed it within days. Families were left confused and some people had their release dates changed.
If your loved one had a halfway house date change because of that April 2025 policy, the Bureau of Prisons says it is restoring those previously approved dates.
But here's the critical part. Do not assume the correction happened automatically. You need to verify it directly with case management staff.
Call, write, or have an attorney reach out. Ask specifically whether the placement date that was changed has been restored. Get it in writing if you can.
And with this new director-level policy announcement, families should also be asking whether their loved one has been evaluated for home confinement eligibility under the updated guidance.
If the Bureau of Prisons is saying barriers should be removed, then case managers need to be acting on that. Push for the evaluation. Do not wait for the system to come to you.
We will keep watching this one closely because policy announcements and actual implementation can be two very different things at the Bureau of Prisons.
All right, we have to move to a story that is genuinely alarming. The Department of Justice Office of Inspector General released a report on USP Canaan in Waymart, Pennsylvania.
USP Canaan is a maximum security federal prison, and the Inspector General found serious medical failures during its inspection.
At the time of the inspection, USP Canaan had no on-site physician, no doctor, at a maximum security federal prison.
The report also found significant delays in laboratory testing, a backlog of outside medical referrals, and expired emergency medication that was still in circulation.
Expired emergency medication still being used. That is not a paperwork problem. That is a patient safety crisis.
Inspectors also found hazardous materials stored improperly. The failures at USP Canaan touch on healthcare, programs, and medication access for the people held there.
If you have a family member at USP Canaan, we want you to know this. You have the right to ask about their medical care. You can write to the warden and to your congressional representative.
Attorneys can also file requests for medical records or raise these issues directly. The Inspector General report gives families real documentation to point to.
The Bureau of Prisons has a legal obligation to provide adequate medical care under the Eighth Amendment. A facility with no doctor and expired emergency drugs is not meeting that standard.
We hope the Bureau of Prisons acts quickly to address these findings. People at USP Canaan deserve real medical care, not a system held together with expired supplies and no physician.
Now let us talk about RDAP, the Residential Drug Abuse Treatment Program, and some changes that took effect on May 7, 2026.
RDAP is one of the most valuable programs in the federal system because it can earn eligible inmates up to 1 year off their sentence in addition to other benefits.
Under 18 U.S.C. Section 3621E, the law authorizes that up to 1 year sentence reduction. But the Bureau of Prisons has now changed how it calculates who gets what.
The new rule is this. The full 1 year reduction is now reserved only for inmates serving 37 months or more. If your sentence is shorter than that, the credit you can earn is reduced.
That is a significant change. People who completed RDAP or were planning to complete it, expecting a full year off, may now receive less time than they anticipated.
If your loved one is currently in RDAP or on a waiting list, they need to talk to their case manager about how this new rule affects their specific situation.
And if they were counting on that full year to hit a specific release date, that calculation may need to be revisited. This is not a small thing.
Attorneys should also be reviewing their clients' cases in light of this change, especially if the original sentencing strategy involved RDAP as part of the release plan.
We know a lot of families have built timelines around RDAP. If those timelines were built before May 7th, 2026, they may no longer be accurate. Please check.
And this is exactly why calculators and tools that stay up to date with Bureau of Prisons policy changes matter so much for families trying to plan.
Our final story today comes from the Supreme Court of the United States. On May 28, 2026, the court issued two decisions that significantly restrict compassionate release.
Compassionate release is the legal process under 18 U.S.C. Section 3582 C.1a that allows a federal inmate to ask a court for early release based on extraordinary and compelling circumstances.
The Supreme Court has now substantially narrowed what courts can consider as extraordinary and compelling circumstances. That is the legal threshold you have to clear to even qualify.
In plain terms, it is now harder to win a compassionate release motion. Courts have less flexibility in what they can consider when deciding whether someone qualifies.
These rulings were analyzed by attorneys who described them as significantly limiting the standard. If you or your attorney had a compassionate release motion in progress, this matters immediately.
Any motion that was drafted before May 28, 2026, should be reviewed by an attorney in light of these two decisions before it is filed or while it is pending.
If a motion was already filed, your attorney needs to assess whether the arguments still hold under the new standard set by the Supreme Court.
We want to be honest with families. This is a setback. Compassionate release was already difficult to win. These rulings make it harder.
That said, it is not impossible. The pathway still exists. It just requires more careful legal strategy and documentation of the specific circumstances.
Families should also know that the Fourth Circuit, the federal appeals court covering Virginia, Maryland, North Carolina, South Carolina, and West Virginia, has been issuing its own restrictive rulings on First Step Act credits.
The Fourth Circuit ruled that if any part of a combined sentence involves a disqualifying offense, the court will not separate the sentence to apply First Step Act credits to the non-disqualifying part.
That means if someone received a combined sentence and any underlying conviction disqualifies them, they could lose all First Step Act earned time credits, even for parts of the sentence that would otherwise qualify.
This is a serious legal issue for people in the Fourth Circuit, and it is one more reason why having current legal counsel who understands First Step Act rules is essential right now.
The legal landscape is shifting fast. Families need attorneys who are keeping up, not relying on information that was accurate 6 months ago but may not be today.
Let us do a quick summary before we close. 1. New Bureau of Prisons policy on home confinement expansion. Push for your evaluation now and verify any restored placement dates.
2. USP Canaan had no doctor, expired emergency medication, and multiple medical failures. If you have a loved one there, reach out to staff, your attorney, and your representatives.
3. RDAP sentence credits have been reduced for inmates serving less than 37 months. Recalculate your timeline if this affects your situation.
4. The Supreme Court narrowed compassionate release standards on May 28th. Any pending motion needs to be reviewed by an attorney under the new rules.
If you need help calculating FSA credits, release dates, or RDAP timelines, visit FSA4U.com, the only calculator that actually gets it right. And if this show has been helpful, please subscribe and leave us a review. It helps families just like yours find us.
Thank you for spending part of your Sunday with us. To every family waiting on the other side of a phone call or a visit, keep going. You are not alone in this. We will be back tomorrow.